You ready?
Yes, our photographer is going to take a few photos and then we'll start. Right, welcome everybody. It's great to see a lot of familiar faces. Actually, people some I had forgotten about have popped up today, which is a tribute to our speaker today. I'll speak about our visitor today, Justice Kohli. You may also, I'm Professor Alan Dignam. I'm Professor of Corporate Law here at Queen Mary. You may wonder why Professor of Corporate Law is rocking up, because there is a member of the Supreme Court here. But I am, as well as being a sort of corporate professor, I'm particularly interested in the common law and common law heritage. And there are certain judges around the world that you can point to and say, these are not just great judges, these are really significant figures in terms of shaping the direction of their society and in terms of shaping the common law globally. One of the weird things about being a judge, I'm not a judge, but I do deal with a lot of judges, is you don't see the impact of your work for quite a while. It goes out into the world. Like Justice Kohli is an incredibly modest person, but she's probably surprised that, corporate law professor is sitting there last Thursday, and I got an email saying, "Oh, Justice Kohli is coming," and I thought, "Oh, is that right? Did I get that right?" I went off, came back, said, "Oh, great, okay, fantastic," and I sort of thought, okay, what am I going to say about, or actually I took to Ajit and said, can I say a few words about Justice Kohli, because I want people to know how important she is. Like I said, you've got to be a particular type of judge to really have influence both in your society and outside of it. I'd be here even if she wasn't on the Indian Supreme Court. Her decisions around issues such as maternity leave, defining the edges of adultery, divorce, protection for juveniles in court, these are really significant decisions in terms of Indian society, and they also require you. This is the difference between a good technical judge and a great common law judge. They require you to identify those moments when you know you can make a difference, and be brave enough to step into those decisions and make them, to do the right thing. That's really hard. It's particularly hard if you're a woman in the judiciary, because you have a lot of scrutiny on you, and people like to point out mistakes. So I am absolutely delighted that Justice Kohli has come to visit us here in Queen Mary, in the centre of the common law universe. It is really great as well. You can always tell the character of an eminent judge by what they'd like to do. And I love it when they want to do what we're going to experience today, which is her journey, the question and answers around that, and to expose you, the students and the alumni, to someone who has had an extraordinary career. Because sometimes I think in universities we can sort of present you, oh, here we are in the university, or here you are after graduation. And then suddenly we present you with these immensely impressive people, as if it's sort of, they left university and then suddenly they're on the Supreme Court. And it doesn't work like that. And the journey is squiggly, it's all over the place. And then you get there. There are ups and downs. So I'd like to hand over to Ajit, who's done a fantastic job on today's event, and the other committee members. Again, congratulations and thank you for organising this. And I'll hand over to Ajit for the next part of today's proceedings.
Thanks so much, Alan. And good afternoon, friends, students from India, and members of Center for Commercial Law Studies. Today, it's a great honor to have Justice Kohli. Justice Kohli, the Supreme Court Judge. So it's my great pleasure to moderate this session today. We are honored to have Justice Kohli, a distinguished judge from Supreme Court of India. Justice Kohli has a remarkable journey as a lawyer to one of the highest judicial position in our country. She is not only inspiration to me, but all of us who are present over here and outside. Today, we are going to listen to Justice Kohli, her experience, her challenges she faced, and her insight on representation of women in legal profession. We'll also explore realities of a judge from beyond the perceived glamour and discuss the future of Indian judiciary. Justice Kohli, thank you so much for visiting Queen Mary, and I will encourage all of you. We'll have a brief Q&A, but I will encourage all of you to ask questions, be open about it. You won't get too many opportunities of this kind where you are actually seeing a Supreme Court judge in real life interacting with you. So take best advantage of it. Justice Kohli, I would like you to come and say a few words, introduce yourself, and then we'll go into Q&A.
Good afternoon. Pleasure to be here. Sir Dignam's been kind with his book. Thank you for that. He's given a perspective of how we all graduate and move on in life and probably don't expect to reach the highest court of the land and still do. That's a different journey. We'll talk about it. Mr. Mishra was the one who suggested as a chairman of the India chapter of the Center for Commercial Law Studies in Queen Mary that I come and interact with you, and I'm glad that I accepted that request. It's different to deal with professionals and talk to them on fora like the LIDW, and it's entirely different to interact with a student community. So I wanted a mix of both, and here I am. To start with, I'd like to give you a little perspective of what are the skills you need to hone as a professional. I'm sharing with you some thoughts that I had shared with my alumni, the Campus Law Center at Delhi University, where I was recently invited to inaugurate a moot court. And we had those several young students and thousands who had come to attend that particular moot court not too long ago. So I'll start by telling you that welcome to the best years of your life. I stand before you not just as a judge, I'm a reflection of all that I have imbibed as a student over all these years, starting from my days in school to college and to the law college, and finally the biggest institution of life, which is life itself. Some of you are on the verge of entering it, others have already made that foray into your professions and are here probably to just touch base with your college. To my mind, your education is nothing more than a dress rehearsal of a life that is yours to lead. What you imbibe in this institution and those that you have attended lays the foundation of your legal career. Your teachers, believe me, you are not your information banks alone. They are your guides, they are your mentors. And during my life, in the campus law center in Delhi University. Really, what I remember most is the end of the class interactions that we had with our lecturers, with our teachers, than just the lectures that we delivered. And I still remember the fond memories I had of my own self and my classmates going to the campus cafeteria and grabbing a glass of tea or samosas and discussing what we learned in that day or what we attended in that day. And that was a high point of the day. I'm sure you must be having your own set of high points here, but quite close to, I should think, of what probably I did several years ago. So friends, what are your skills that, to my mind, you need to hone when you become a professional? I just touch upon it and leave you the thoughts. And when I talk about professional, I'm talking of a legal professional, obviously. So the first one of the mantras I thought was think twice, speak once. As lawyers, it is expected your best ability would be to speak with confidence. People have a perception that when lawyers speak 19 to the dozen, by and large, that is the perception. It doesn't hold true for the good ones, is what I will tell you. Matured and experienced lawyers do not ramble on. They're expected to be good listeners. They're expected to be dot on the legal point involved. They're expected to be precise in their arguments and very clear in their analytical skills. So learn to sharpen these skills while you're here, and when you're nascent in your career, it'll stand you in good stead. 2, be aware of how you look, how you speak, how you stand. You're being watched, maybe not being criticized, but being watched. Remember that the first impression can be the last one. When I say look good, obviously I don't mean dress up and come really topped up. No, not at all. All I'm saying is that when you look good, look smart, look professional, look clothed in. And then when you're outside the four walls of your university, of your institution that you belong to, you can be its brand ambassador. Never let the institution down is what I'm trying to say. When you go out, they should know that this is a student from this particular institution and stands for all that the institution stands for. 3, show a positive outlook. Be honest and hardworking both. Your positive approach will help you in overcoming those difficulties that you will face not just during the study time, but much beyond that when you embark on your careers. And believe me, it's a very tough profession. There is no substitute for hard work. Long hours, intense pressure of work are all inbuilt into this. So it's not that 100% that you need to do. Sometimes you have to give that 10 plus 100% when you must try to achieve to stand out in a crowd. That should be your hallmark. And how do you stand out in the crowd would depend on your USP. So mull over it. Think what your USP is and work on it so that you stand out. That's important. Again, don't be overwhelmed. Be respectful, but never be intimidated. At the end of the day, let's not forget, we are all just humans with emotions, with anxieties, and a host of feelings. Your college will surely equip you with a degree, and more than that, the real life skills. So things like moot courts that engages us a lot these days, and it's happening all over the world, internationally, nationally, whatever. Those are only prelude to the real thing. That's not the real thing. This is, apart from education, what perhaps is expected of you is to develop those soft skills. And what are those soft skills? Like being efficient in interacting with people and their problems and understanding them. Lawyers are people's persons, and they are expected to master the communication skills. So whether you are going to be a litigation lawyer, a transactional lawyer, or any other field which relates to law, it's important for you to be able to communicate and clearly. So when you go out and intern at law offices, in chambers of seniors, in firms, keep your eyes and ears open, be a sponge, just soak in as much as you can. And when you can retain whatever will stay, it'll stay for a long time, help you in dealing with all kinds of situations in the future. So again, don't be afraid to ask questions. As I said, don't be intimidated. If you don't ask, frankly, nobody will tell you. Nobody expects you to know everything. Don't go with a mindset that if you ask questions, you're going to look dumb. And we've all done that. We've all gone through it. I'll share my experience with what kind of stupid questions I thought on hindsight I asked. But I think I'm glad I did, because I would continue making those mistakes if I wouldn't have asked. You will learn as you go along. Just be willing to do so, be it as a teacher, in a clerk, in the office of the law firm, or the senior partner, anybody. They all have something to teach you. As long as you're willing to learn, you'll find those particular areas of knowledge. Next, don't put off a difficult task. When you're struggling to get started, don't think of the pain that you will experience in the beginning. I emphasize, focus on how good you will feel when you complete that work. Nothing can beat the satisfaction you get when you have cracked a particular problem all on your own. So don't procrastinate. If a tutorial has to be written or a project completed, try not to push it to the back burner. Accept the challenge and get on with it. Imagine the satisfaction you will have at the end of the task, and that is what will give you a high. Another issue which I may touch upon, a pedigree. Maybe many of us have it here. Maybe a good stepping stone, but it is not the only way you need to go. The only way to go is actually go for it, actually knock on the door and run through it. Those of you who do not have any family members, any relatives, any friends in the legal profession, like I didn't, don't think that it is a cause for being disheartened or feel inadequate. I do not come from an illustrious background, which is legal. No one in my family has done law or belonged to the legal profession. Unlike the situation today, when I had started my career in mid-1980s, there were very few women in the Delhi High Court in the profession of litigation practice. But, well, that didn't deter me. I didn't know that, of course, that I'll end up being a judge, much less a Chief Justice of a state high court, and then a judge of the Supreme Court when I started. But then at the end of the day, when you look back, hard work and perseverance does pay. As for the perception that it is to do with sheer luck, I would like to quote Thomas Jefferson, the third president of the United States, who had said, and I quote, "I find that the harder I work, the more luck I seem to have." So let's remember that, and let's remind ourselves of that. Success at the end of the day is not measured by your salary, by your title, by your degrees, but the impact that you have on others and the collective happiness of the people whose lives you touch. Learn to be dispassionate, no doubt. As lawyers, you have to be. You're professionals. Learn to be objective when you discharge your duties, but never be clinically cold and indifferent. Ultimately, you're dealing with individuals, you're dealing with their problems, you're dealing with their jobs, you're dealing with their families, with their properties, and their lives, as also those who are attached to them. Doing financially well as a professional is imperative, undoubtedly, but that is not the end all, and that is not the be all of being a professional. If your heart is in the right place and you listen to your inner voice, however feeble it may be, you'll never go wrong. So that little voice should never be permitted to die. Skills, when it comes to skills of legal writing must never be underestimated. It's the fundamental to our profession. It is critical that there be clarity in your thought, in your legal arguments, and for maintaining the integrity of law. Well-written legal documents and scholarly articles help develop legal theories and interpretation of law. They advance the standard of our legal system. Every well-researched and analytical document, article, not only enriches your legal knowledge, it also enhances our collective understanding of the subtle nuances of law. In today's rapidly changing world, staying abreast of the legal developments is equally imperative for legal professionals. I remember we didn't have the benefit of AI. Everything had to be done by going to the library, actually pulling out a book, looking at the references and the precedents. It's so much easier for you now. Take advantage of it. So the ability to serve a client effectively and participate meaningfully in the democratic processes depends on your continuous engagement with the current legal affairs, not just of the country that you belong to or the country you are in, but globally. And finally, remember, you have a worth. You are all investments in the future. I remember what the chairman of Yahoo, Maynard Webb, had said, and I quote, "If you're willing to dream, then work hard and execute well, you can achieve more than you can imagine." At the end of the day, we're all human beings and bound to make mistakes. So will you. So please don't lose heart. Don't be overcritical of yourself. We have all done it at different stages of life and gained from it later on hindsight. Remind yourself that success is not final, failure is not fatal, and it's the courage to continue that matters. And that is what, in brief, I'd like to say as far as the multiplicity of the role of lawyers is concerned. Well, you all know that we wear multiple hats as lawyers, as litigators. There are arbitrators, there are negotiators, there are counselors, there are advisors, we have strategists, all within the legal framework. Some engage in public policy, others contribute to the academia. We have others who would like to work with NGOs and issues relating to social justice. So these are multifaceted involvements that will contribute to you as enriching you, making it a more nuanced legal environment, becoming increasingly aware and clear that modern legal practices is not about mastering one area of law. It's about understanding the interplay of multiple disciplines. When it comes to first generation lawyers like myself, well, in India, the legal profession has witnessed remarkable changes in the demographic composition of over the past few decades. That includes a positive shift, which is the rise of the first generation lawyer. Those of us who don't have anybody in the family who's in law, who have not done anything but themselves to enter the legal profession, there's a notable increase in the representation of not just women, but all kind of inclusive categories in the legal profession. These developments are not just statistical points of interest. They show how the society has grown. They show how profound the implications for expanding the ethical dimensions of a legal practice are in the country. It has been there, not there for long, but long enough for it to become established and rooted enough. So the fresh perspective, I think, of a first generation lawyer is imperative because they come with a sense of purpose, a sense of mission that transcends the normal traditional boundaries. Unlike those who may have had maybe an inherited legal practice or have had lawyers who have come from families of lawyers, the first generation lawyer will always bring an outsider's perspective. And that can challenge the long-standing norms and practices that have become hardened over period, becoming traditional, accepted. That's where you break the mold. So this is critical for stimulating an ethical dialogue within our legal community. The first generation lawyers, I find, are more inclined to question the established paradigms, be it attorney-client relationship, billing practices, be it ethical considerations of advising the clients with conflicting interests. By doing so, the first generation lawyer compels the entire profession to revisit and reevaluate some of the most foundational ethical principles. These queries also challenge to serve us with a refreshing ethical audit of sorts, compelling the legal community to introspect, to adapt, and to acknowledge a completely new point of view. Again, interplay between diversity and ethics, the inclusion of the first generation lawyers and increased representation of women like me and many of us in the legal field have no doubt transformed the ethical landscape of the profession. Their contributions are rich with diverse perspectives, with challenges that have challenging established norms, bringing fresh air, bringing impactful ideas centered on social justice, on fairness, on equity, on most of all, rule of law. The COVID-19 pandemic was a catalyst for changes in the work-life balance that we've had, particularly normalization of remote working. Law firms have adapted all over and in India dramatically. With this particular change, there has been more balance between and flexible working environments. It's really helped the women lawyers who've been able to cope with the situation at home and still log on virtually and do their matters in courts without stepping out of their home and house. It has enhanced inclusivity. It has provided opportunities that were previously limited or maybe unavailable till COVID-19 actually happened. And we continue with our virtual mode in all courts across the country, in arbitrations, in mediations, and they have done wonders for the whole system. So ultimately, the growing diversity and inclusivity within the legal profession not only enriches the entire dialogue, but also shapes and improves our legal framework and the societal norms. To conclude, at your age, you have the luxury of time, which many of us don't. So think carefully, implement skillfully, make mistakes and learn from them. As a history student, we were taught that history never repeats itself. It certainly won't for you if you carry the lesson of your past mistake. I conclude by reminding you that we are very good lawyers for our mistakes and excellent judges for others' mistakes. Reverse the roles and see the difference. Thank you. Thanks so much.
Thank you, Justice Kohli.
Yep.
I would like you to remain over there.
Okay.
There's a chair.
Okay.
Please make yourself comfortable.
Sure. Sure, I will. Yeah.
And since I'm chair of India chapter, so I'll take the liberty of asking first questions.
So what I do is I move the chair. I can't see that side of my audience.
I'll help you.
I think it'll be a good idea if you can help me. Can you move it there a bit? I need a view.
Where is that chair?
So I'm okay even with that.
Whatever is comfortable for you.
I'm very happy. Let me stand. I'm okay. I haven't forgotten to stand in court now. Judges tend to sit, but it's always normal for us to stand when we are in court. I'm good. Please go ahead.
So yes, so you mentioned you being a first generation lawyer, and I'm very sure in this room we have got first generation lawyers, some women lawyers,
Yes.
or the budding women lawyers.
Right.
So my first question is,
Yeah.
why you became lawyer? What motivated you to be lawyer?
Should I be candid? So it's not
Honest.
it's not a great story. So I did my in my college, I went to St. Stephen's College in Delhi University, and I did history honors. History happens to be a subject which is a very favorite of my maternal side. So my mother and my grandfather and all the academicians on my mother's side were mostly into history. It came naturally, perhaps. Having done that, I went on to do my post-graduation too in history with special emphasis on medieval India. Law was nowhere on the horizon. And my batchmates and contemporaries from my college were well known to go in for the civil services. So we had to prepare for the examinations. And many of my contemporaries were doing that. And my family said, why don't you give it a try? So not very happy, but with some reluctance, I thought, all right, let's get into preparing for the civil services, which I did. And then suddenly I realized that I've completed my post-graduation and I needed access to the library and the university, which could only be by joining law. So here I was, I showed up and enrolled myself in the 3-year course that we then had as a lawyer, and to train myself, and we had the access to the books and everything else. And the civil services exams came and I took it. But by then, in the back of my mind, I was getting inclined towards law, and having closely observed how my lecturers and others were teaching us, I thought I'm going that way. But then my family felt, particularly my dad, who comes from a business background, said that, nothing like doing the civil services. It has so much of honor and prestige and all of that. So we bargained and I said, okay, just to prove the point that I can do it, I'll take the exams, but there's no guarantee I'll go through it all. I think they took it with a pinch of salt, thinking if she does get through, she'll obviously opt for it. Nobody says no to a civil services. It so happened that I got through with the preliminaries. And I said, okay, now you've seen it, I can do it. Now I don't want to go ahead. And I want to complete my law and go ahead with that. And I had a lot of backing for my mom. She was very gung-ho. She was brought up on a good, healthy diet of Perry Mason as an Earl Stanley Gardner. And she felt this is the way to go. And there was no good reason why I shouldn't. So here I am. I showed up and I joined the senior and I went into law.
Excellent.
Yeah.
Being a lawyer, a woman lawyer,
Yeah.
practicing in India, are there any challenges which you faced?
There are plenty of challenges. I'll be first one to admit it because in mid-80s, when I joined my career, as I was saying to all of you, there were very few women in litigation. You could count them on your fingers. There weren't too many. The attrition rate of women lawyers was very high then. Even now, it is fairly high for the simple reason that when they choose to tie the knot, many of them take a break from their professional careers. When even after marriage, if they continue and they have to bring up a family and they again take a break because childcare and all that takes a lot of toll on them. So the attrition rate is high. That is one. So if you overcome that and you're steady on your path, then you continue making the difference. So more than perhaps not just the litigant who has some reservations about approaching you when into your pure litigation practice, seeing whether you have the experience or not, what is your backing, what is your background, he has to or she has to pay a fee for your time. So obviously they're going to do a due diligence. I mean, when you're freshers, you don't have that kind of a CV that you can give to a litigant and say, look, I've done this and I've won those cases. If the proof of the pudding is always in the eating, they want to see the results in their case. It's difficult. Your own colleagues have a little reservation about your seriousness in the profession. So you have to break the glass ceiling, not only of your own colleagues, of the litigants, but also to establish before the courts before whom you appear that you are serious about your business, that you're not there to seek an adjournment. You're not there to seek a passover because your senior is held up in another court, that you're there with your file well prepared and ready to argue in case the occasion arises. Those are the challenges I think that are still being faced to quite an extent by women practitioners even today, but maybe not at that scale. The professional skills have increased. They are more serious. Sometimes I marvel at how beautifully they are negotiating their work and their life. That's what I would say.
So my first boss, she was a lady and she was exceptionally harsh on me. Exceptionally harsh, but at the same time, and there was a time when she took me out for dinner. She was nice. She was very nice. She's still a very dear friend. Okay. But she took me out for a dinner. And I asked her, why you're so harsh on me?
Right.
She said that because I worked very hard. It was not easy. And I want to see yes. Same in you. Work very hard. So she was my first boss, first teacher, and still my very dear friend. So now, generally there's a perception that judge's life is very glamorous.
Yeah, true. That perception is there. We are trying to break that perception. Take us a little time to do that.
What is the reality?
Look, if you look at the exterior, well, it looks as if we have a very cushy life. The Indian judges have spacious bungalows that go as part of your perks. You have a driver, you have a vehicle, you have personal security officers. It looks very fancy from outside. But to be honest, I'm speaking for myself and for many others who are in my position. It's a very hard life. It's a very lonely life. You don't have the luxury of time. You don't have the luxury of spending time with your family, much as you would like to. There's a lot of compromise even in your sleeping hours. Many times, perhaps, I was in the High Court, unlike Supreme Court, the systems are different. In the High Court, when you work in the chamber, even after court hours, you tend to complete your work and go back. So it could be after court is over, the public hearing is over at 4:30. Then we start working for the next day, for the day's work and all of that. That can go on to 8 or 9 p.m. And you carry the next day's files with you so that you can study in the night of the next day. In the Supreme Court, we have home offices. So we don't stay on in court except to do our hearings, etc. We finish work and come home. And our home office works in shifts 24/7. Because anything can come up at your doors at any time, whether it's vacations, it doesn't matter. Working days, of course, late hours, of course. I myself, with Honourable the Chief Justice of India today, Justice Chandrachud, have actually sat in court till 9:20 p.m. on a particular day because our court couldn't get over. So those are challenges which people don't realize. It's a lonely existence. You have to be very confident and comfortable with your own self because you're not going to meet a lot of people in the course of your working hours, except your private secretary or your law interns or law researchers. That's it. Or maybe colleagues or administrative meetings. That's it, nothing else. So if you are not comfortable with yourself, with your space, you could feel it to be a very lonely existence.
And definitely it's very hardworking.
Yeah.
There was a news article when current Chief Justice completed his 100 days as Chief Justice. There were 14,000 cases which were disposed of in 100 days.
That's true.
And we are so it's definitely a very hard life.
I think we will open up to the room here first, and then I'll share the question.
Sure.
Yes.
I can move the question.
Yeah.
I've always asked this question whenever I meet someone senior in the profession. That what is the most challenging case where you think you thought differently, both at bar or at bench? Do you have any?
There are many challenging cases. I can't pin it down to one. In a career spanning over 18 years as a judge and 22 years as a lawyer, there have been challenging cases. Those that engage one, I'll be candid. See, one is the normal commercial litigation, arbitration, commercial suits for specific performance and all of that. Those are matters of the moment. You handle them in a particular way on a set pattern. The challenges come when there are new ways that you have to foray into law and create, which your professor highlighted. So you look for that moment. That should define your time and your input and your help in progressing the judicial path. So those sometimes can come your way, but you have to keep your eyes open for an opportunity. I'll give you an example of one of my first cases after I became independent as a lawyer. There was something called a parent-teachers forum, of which one of my friends was a professor herself and principal subsequently of Hindu College, Delhi University, who was my contemporary in law, said that these class 10 students had a question that was posed to them and in mathematics, and the answer was wrong. And that was critical for them to have been able to clear and get a better result. Now, normally courts don't interfere in these kind of things. There are expert bodies. Once they set a standard, it goes to them. Whatever they do, that's the final word. Incidentally, the bench before whom we filed that petition and which decided it finally, the senior bench partner was Justice Dalbir Bhandari, who's now in the International Court of Justice. I had the additional Solicitor General of India appearing against me, and I was a fledgling. And we worked really hard on those questions, broke up that question into 4, and how did the answer take place, and how many minutes. The grievance of the students was that the question was too long, and we couldn't have answered all of it within the time frame expected of us. After all that struggle of answering it ourselves, sitting down with the parents and all of that, we actually had a bench that sat and solved that question on the dais, timed themselves, and finally agreed with us that yes, there was something to be said about it. And there were some kind of qualifying marks, that grace marks that each student who attempted that question would get. That kind of satisfaction of knowing that you had made a difference to the student community, and that was a pro bono matter, was the best thing. That I think I was so elated that it made a difference to all of them. And perhaps that was one of my first cases that was covered in the press that gave me a great high. So I still remember. Then life goes on, you take things for granted, but the first one always stays with you. So that was a matter, as I said, which had nothing to do with your fee, except your involvement in the cause. Those are things which you will find in your future will stay with you. So whatever I may have earned and billed and got huge fees for was not what stayed with me. They were just clients. These are these kind of matters that really make a difference to you, and you carry it in your heart. I'm remembering this, and I'm talking of late 80s, so you can imagine that I still remember it and very well. So those are things that I think stay with you. One of the examples was this. Yeah, sure.
So for a person who's fresh out of university, right, and intends to work in litigation alongside, arbitration and other alternate disputes, how do you suggest that we go about it?
So look, this impression that arbitration is standalone and you can make a career of it when you just enter the field, I'd like to dispel that. It's important for you to become a well-rounded litigant. And that would mean that whatever comes your way, right? In the process of what comes your way, there could be matters which the parties want to refer to arbitration. We do have court annex mediation centers, many courts in India, many state high courts, even the Supreme Court. And in the course of that, if you get an opportunity to hone your skills, certainly do that. Of course, we have trainings for mediators also, but that needs some lawyer skills. So till you get those skills, you would not perhaps qualify at that point in time in the nascent stages to become a mediator or an arbitrator. And those are really niche areas. So for you to, I would say, to make them grow together, you need to grow in your career as just a lawyer. You could be in any field, but simply as a lawyer. Rest will follow depending on the nature of work that comes your way. And let me tell you while we are at it, you can't make up your mind that you will be a specialist lawyer on the criminal side or the civil side when you get into litigation. It's the nature of matters that come your way, and don't refuse the work. So if the more that comes your way and the more you are able to do it, the more you'll be able to gain and learn, and then make up your mind. If you're able to give good output, naturally clients will gravitate towards you. Then this is a word of mouth business. It's not, you can't, particularly we know in India, you can't advertise. So what you perform and what you do in court carries. And those are occasions when, people may be sitting in court and watching you argue in their matter. In somebody else's matter would feel that they want to come to you and give you a brief. So those are word of mouth matters which bring up, opportunities for you to exploit. That would be my answer.
Just one
Yeah.
question is, another just out of university, a student who's just starting
Yes.
their career, like how much time do you think a person is going to take to actually start independent
So the gestation period is long. I'll be candid, when I had joined, I thought my gestation period was around, ideally it would be about 7 years. It's a lot of time. I was lucky. I didn't have the kitchen fires to run. I had a backup. It's not true for all of us. So I would say I was blessed. If you really think that you have to go straight in my time, the fee offered in fresher was very, very minimal. It was just basic. It's not true today. Fortunately, good law firms value the fact that students have studied and spent money on their education and they need to pay back. So they give a good start. But ideally, for you to become a skilled lawyer, nothing less than 5 years would be an ideal measure of your time. Yeah, you're right.
And I'll add one more thing.
Yeah.
Never try to learn at client's cost. Okay. So
Yes.
when they pay for the services.
Yeah. So what happens when Ajit says that never learn at the client's cost is assuming you have a matter of which you are not familiar with or you don't know the legal nuances. Always, without exception, go to a senior colleague and they are very supportive and seek guidance. Your senior colleague need not be your chamber colleague. It could be anybody, your senior in college, your senior from the law firm, anywhere. Learn, go, study, and then get your fundamentals right. First elements and first fundamentals should be clear. Rest falls in place. So as he said, don't learn at the cost of a client, but at the same time, do all your groundwork. And then it's okay. It may be your first brief, but you should be thoroughly prepared. And always prepare from the perspective of the opposite side. Never from your own perspective alone. You don't know what the other side's strengths are, then you are lost in court. When you go in, you must know what are the strengths and weaknesses of your case and what are the real strengths of the other side's case. When you start with a matter, the other side isn't there till notice is issued. So you're on your own. Till you're able to convince the judge, there's no go, right? When you enter the stream, when notice is issued, there's going to be somebody coming from the other side to question you and what your perceptions are or what your arguments are. Be prepared for that moment. If you aren't, then you've lost the battle.
My question is, how do you deal with the scrutiny from the press? Because although judges do not have a direct interaction with the media, there are no press conferences, and especially now since there are live streamings in the courts, so there's a lot of scrutiny on the judges, and sometimes the comments can be really harsh.
Yes.
So how do you deal with it, and more importantly, how do you not let it affect your judgments, your decisions? Because
for me,
we're all humans at the end of things.
For me, it's simple. I'm not on social media. I'm living in an insulated world. The lesser I go into that, the more chances are that I remain balanced and I do my thinking process on my own. The moment I go that way to my mind, then I will also be influenced by what is being said or written. And I'm sure that we all do things where we are criticized heavily, but in a democratic setup, it's a free world. We always say, and it's a basic norm, criticize the judgment, not the judge. And if you do that, find fault with the judgment, there's nothing wrong with it. There's nothing like contempt of court when that happens. You're free to criticize the judge. When it gets personal, it is brought to your notice, then it's a different matter on the judicial side. But for my own self, the best thing is to remain insulated from all of it till you're on the seat. Step out, become active if you want to, your choice on social media. As long as you're here, it's best that your judgments answer for yourself. And you don't need to explain things to. And that's how it ordinarily works. And of course, we have a Secretary General or a registrar. If really something were to be patently false, it's for them to put it up to the press, but not for us as judges. This institution demands some insulation. One must respect. That's what I would say. Yeah.
Nowadays, big corporations and clients, my personal experience and my colleagues have always had this, whenever I talk to them about arbitration, is that it's almost as time consuming as litigation nowadays. Big institutions being involved, multinationals being involved, cases, these arbitration hearings can go up to a decade almost. What would you suggest to, when what we learn in basic law school is that, always go for arbitration because it's less time consuming and less cost, it's also cost effective. And always have that clause in your contract. But seeing the current condition, what would you suggest to implement a better, more effective and efficacious method towards arbitration?
So it's not just the arbitrators who have to train themselves. Sometimes one finds that the arbitration award has been delivered within a good, reasonable frame of time, and it gets clogged in the judicial machinery when a Section 34 challenge is made or a 37 challenge is made and it gets blocked. So one is to have the processes in place in the arbitration itself. What are the due diligences and processes that will curtail the whole timeline, as in the pleadings, the claims, the counterclaims, the affidavits, the evidence, and all of that. That's one. And thankfully, virtual has helped to save time when you are virtual and are able to communicate with others across the globe, across the country, get things going. You don't have to physically present yourself before the arbitral tribunal. That's one part that has been helping. The other is to train ourselves as judges. And when we have the district courts, which are the first commercial courts, because jurisdictions are huge now, pecuniary, we do have training modules for our own judges from the district courts. We enlighten our High Court judges through academies. We have the state judicial academies, we have the national judicial academies. to tell them how important it is, that commercial matters shouldn't be detained for that long, that interference should be minimal, that unless there is something really, really for a domestic award, patently illegal or goes to the root of the matter, interference is not called for. So that is self-training that we need to do constantly. I would say most of the High Court judges are fairly familiar, and as Supreme Court, of course, we are. Sometimes the district court judges who come into commercial jurisdictions initially do have that approach to it as if it's a civil proceeding. It's not. So that impression must be dispelled, that they should be assured that there's nothing wrong with throwing out a 34 if there's nothing in it on the first day itself. You don't have to let it enter the stream merely because it's a challenge to the award. So that kind of honing of skills is important to my mind to curtail the timeline. Absolutely. And timelines don't stop running when an award is upheld by the court. Timelines start running when you have to implement the award. That award is an empty decree if there is nothing that the litigant succeeding in the case gets at the end of the day. Any expectation is that if I have won, then where is the result? That is important and equally important for the court processes to do. That it should be in and out as quickly as possible. That should be what our focus. Yeah, you're welcome.
Good afternoon, ma'am.
Yeah.
Firstly, thank you so much for such an
My
engaging
pleasure.
session. It feels surreal to, having watched you hear cases in Delhi High Court when I was interning to now actually meeting in person. My question is in furtherance to the scrutiny question that my colleague asked. How do you think in public trust and confidence be increased in any judicial system for that matter? With so much scrutiny.
So it's just the transparency of the system. I think that is the biggest public trust. If you're open, and these are open court hearings we have, it's nothing behind nothing in the chamber. You know that everything is there before the litigant, before the lawyer. We have virtual courts, which all clients now log into, what their counsels argue and perform, which was not the case earlier, unless a client actually trotted into court, and how many did? The least in the High Court, lesser still in the Supreme Court. They have the luxury of now asking the lawyer for a link and logging in and hearing you and seeing what the judge is saying and what the lawyer is saying and how well equipped he or she is and how has he answered the questions being posed to the court. Nothing could be more transparent, I think, than an open court hearing. And that kind of transparency and what we say, let the sunlight in. And if it does, and it is happening regularly, that mindset that people may have that, something went wrong is dispelled. So it is, if you constantly do that, that itself becomes a motivation that the public trust and the confidence builds in the institution. And at the end of the day, each of us are part of that institution. A lawyer is as much a part of that institution as a judge is. They may be two sides of a coin. They're performing their roles in their different dimensions, but they are part of that institution. To give confidence and public trust, it's equally important for the lawyer to convey to the litigant that there is nothing like suspicious or suspect, and that impression that many people carry that, somebody's been bought over, there's been something more than meets the eye, or it's really smelly. It is as much for a lawyer to convey to the public at large that this is how the system works. It's open to scrutiny. There is an appellate court. That's not the only court. The first court you may not succeed, but there's always an appellate court. And we tell ourselves in High Court, when I was a High Court judge, that thank God there's an appellate court. If I've gone wrong, it can be corrected by an intra-court appeal. And if you're in a division bench, by an appeal to the Supreme Court. So the systems should be in place. They should run flawlessly. It should be a well-oiled system. And that's how the transparency comes, to my mind. Yeah.
Hi, ma'am. My question is not on law point, but we all know that judges have a very stressful working hours, and as you said, you all remain in isolation.
Mostly.
How do you refresh your? I mean, it gets exhausting after a point. It's more. I prefer listening to music to refresh my mind.
Sure.
What would be?
So I'll share with you the fact that there is this app called Spotify.
Yeah.
For myself, I invariably have it on an instrumental mode when I'm writing or when I'm reading. It just helps me to focus, and I'm able to pollinate in the sense that music is playing in your mind. I think it gives me more focus when I'm studying, I'm reading, I'm preparing for the next day. Just any music, it gets you going. it calms you. It makes you feel good. So it's my favorite thing to do is to just keep that on somewhere and have a speaker next to me. And the room is flooded with music mostly. It really helps. For me, it really helps. Never. You can't interfere in your mental thought process. You want that silence to think. And that is very important for us, that silence. Music doesn't interfere.
Yeah. What kind of music is that?
Anything, Western, I'm not a great jazz person, but anything instrumental helps. I mean, if there are something with the lyric, it doesn't to me. Maybe to others it does. But instrumental calms you down. Any kind of instrumental helps.
So, two questions. First of all, one of the legal side, like you're yourself a judge.
Yeah.
And what we say, there are various other classes which are underrepresented in the judiciary as of now.
Yeah.
Be it the backward classes or be it case or Ukapan, who thinks that he's not there in the judiciary just because there's only sexual.
Yeah.
So what can we do to have these concerns addressed? And secondly, on a slightly different note, so you've been a student of history yourself, and studying Indian history is a very different experience by itself.
Sure.
And then you come to London and you see various streets, various places. You just recollect a lot.
Sure.
Can you share a few of your very favorite moments if you roam around in London with your?
And the latest was, and I'll be happy to share it. We went to, I think, Putney, and on the way somewhere, the driver was with us, showed us that, was it Putney or Hounslow? The place where Bhagat Singh purchased the ammunition from where and then he went to General Dyer and shot at him.
Oh, that was
Udham Singh. So that was like a landmark. I looked at it twice over because you don't relate it till you actually come here and see it. This is something that happened just over the weekend. And talking of inclusivity, I think we've gone far ahead now. If you will notice, whether they are the marginalized, whether they are others from not mainstream lawyers, as you said, or have different orientations. We have some wonderful senior advocates in all courts who are doing so beautifully. And we have those who are sightless, and they have been designated seniors, not just in the High Court, but also in the Supreme Court. And they are doing beautiful work. It's such a pleasure to see the way they negotiate through arguments. We just were able to help them, and they are far more clued in than a normal lawyer with all the faculties going. We have some beautiful senior advocates doing. Again, we have women who have been able to make a mark for themselves. You can see from the fact that out of more than 50 lawyers who were designated as seniors, we had a dozen women who have been designated as senior lawyers in the Supreme Court very recently. Those are things that we need to do all the time. So it's a work in progress. It is taking, maybe from the outsider perspective, it may be that it's taking time, but it's happening. As take my own example as a Chief Justice of Telegana High Court, we didn't have any woman from the bar who was a senior designated. During COVID time, when we did this process virtually, fortunately, I was able to find out, and my colleagues agreed that one of them deserved to be designated as senior. Unlike Delhi High Court, Bombay, Bangalore, and others, where plenty of women senior advocates, that was the first time. That lady went on to be recommended by me to become a judge of the Telegana High Court, and she is one now. She's through and doing good work. So those are examples we need to set, and we need to take that extra effort to hone their skills. I'll share with you, I had in Telegana High Court a young man who came without any background reference, wrote me an email while I was still in Delhi, yet to take oath as a Chief Justice, and said, I am so-and-so. I have no background, legal background. I want to intern with you. He was a fourth-year student. He hadn't completed his law. And when can I meet you? I didn't know him from Adam, but the fact that he reached out to me at that stage made me think that this guy was really serious. He trotted in. I called for him. I told my PS must find him, send him a mail. He came. And he said, I have nobody in the family who's doing anything like that. My father is into professional cooking, catering, and my mother's a homemaker. And I think that if you would permit me, I'd like to associate with your law researchers. That guy did such wonderful work. When I was about to be elevated to the Supreme Court and was moving out, he completed his law. That was July, August. And I called him and I said, now you're all set and you're going to join the practice. So who are you planning to join? So he said, I know nobody. So I said, I think you know me. So maybe I can help. I can help. I prompted him. He says, but I don't need your help. I need to go look for somebody myself and associate myself with. And if I don't find that way, I'll come back to you. Today, that guy's written 3 books, right? He joined a chamber. He came to meet me just last month after a big hiatus. I was so delighted to see the career graph of that child. He's done so well for himself. In that background, with those kind of disabilities, if he was able to do it, it was sheer dint of hard work and nothing else. He's a shining example, I thought, of somebody who could make a difference in the profession. That's it. And he wrote his book and wrote a message for me on it. And I told him to autograph it for me. It was so nice. That's what I think we all need to do.
And as you can
I
see,
just add
they will.
hopefully future Justice Kirpal. I mean, the collegium has sent his name back.
Yes, of course,
more
it's
than
waiting.
twice now.
It's waiting.
Because it's definitely not, the residence is not from
the judiciary. That's
Yeah.
true.
So as you see, everybody is quite enthusiastic talking to you and they won't stop. So can I request you to sit down, please?
Okay. All right. I'll do that. Thank you.
And those who cannot see Justice Kohli, they can come this
They
side.
can hear me. That's fine.
Yeah. Okay.
Yeah.
Hello, ma'am. What is your view on the impact of AI that is coming up, and how will it affect us as being in this legal field? What is your point of view on
I think AI is doing beautiful. But for AI, we would probably not have virtual hearings. We would not have been able to negotiate COVID. In 1 week flat of COVID happening, we were in Delhi High Court, I remember, and as J1, I had to work harder because when you become senior enough, you need to involve yourself on administrative side. We worked day in and day out to get the courts going. The courts did go, and how they went, starting with 10 matters initially, followed by about 20, and we kept increasing the number as if it wouldn't be virtual, the courts would have come to a grinding halt. So again, AI, besides virtual, all the filing is virtual. It's helping us a lot. We've got all our case mat on virtual. Those are benefits of AI that must be accepted. We are trying to do everything to negotiate with the computers, with the systems, with the IT teams, and not just in Supreme Court, pan-India. And I think you'll be aware of it. It's mandatory now that we must have a hybrid going in every court, starting from district courts to the high courts, to the Supreme Courts. We have the pleasure of lawyers logging in from London in hearings, and the other gentleman or woman being right there physically, physical mode. And we have got used to taking files by PDF. Mine is a paperless court. It helps a lot. It certainly does. So it has its advantages. We have to train ourselves. Perhaps your generation is more familiar with it. It comes easier. Some of us need to train ourselves, which we have been doing, to get used to it. High on my agenda is liquid text. I haven't gone around it. So I think I need to negotiate that. So those are things which we do. We have our iPads, all of our meetings are administrative. Are paperless. We have meetings across the country. We log in physically. Nobody comes to Delhi to attend a conference or a meeting. We are all ensconced in our respective states and cities and logging in. What could be a better example of good use that AI has been put? Hello.
Drawing upon on that question, what are the challenges that come with the use of AI in a judicial setup? For instance, what are the controls for data protection, for example, in India, where there is sensitive data which is there in the judicial system?
There are backups. There are setups that we are using what we call safe deposits and lockers, where the sensitive data is not preserved in databases that are based outside India. We have been doing all that to make sure that it is secure, and that is make a firewall. And all the time, the national NIC, the National Informatics Center, is collaborating. We have centers in Bangalore that are collaborating with Supreme Court There are committees constituted in every state high court, which is IT specific, to deal with what are the nuances in their respective courts to safeguard data. All of it is happening and happening at a good pace. So I think we are, and wherever we find there are faults, we try to plug them to as we go along. So it's, as I said, work under progress and happening. Yeah. Yes.
I have something to ask regarding the working of Indian Supreme Court. If you look at it, the US Supreme Court or even Supreme Court here, they don't work for 5 days a week, probably 1 or 2 days a week, and they hear maybe 100 or 200 cases at the most. But in comparison, Indian Supreme Court sits for 5 days a week, hears, to my knowledge, at least 20,000 cases a year. So do you think that the Indian Supreme Court is functioning in a right way by hearing so many cases, by admitting so many cases? In theory, we have to only admit those cases with a substantial question of law, but in practice, I don't think that is happening very much in the Supreme Court, and there really doesn't seem any difference between the High Court and the Supreme Court in India. So,
see, well, it's a question of right to life and liberty, as in bails, anticipatory, and such like. We are fairly liberal in opening the door wide, because we think it's very important that if somebody is not succeeded before the magistrate, before the additional session judge, before the High Court, he or she must get that opportunity to knock at the door of the court, because it's a right to life and liberty. And the doors should be as wide as is possible. You can, it's easier to shut doors and more difficult to open doors. The doors that are open should not be shut on these kind of matters. But criminal jurisprudence has to be built around that. Also, our population. We know what kind of a population we compare yourselves with this country, and there cannot be any comparison. And the judge population ratio is also very skewed in India. So that can be another challenge, both at the High Court level and much more at the Supreme Court level. The fact that there are several legislations that are being introduced and enacted by the Parliament means more a burden on the judiciary, because that also spews litigation. One prime example I can give you was of the Negotiable Instruments Act and the number of check bouncing cases that blocked the entire system of the district courts, and how it had to be dealt with took a long, long time for us to sort out. So those interfaces between the judiciary and the legislature is important to make out what kind of matters will throw, what are the nature of cases that will come up on a basis of some litigation. Also, let us not forget, pendency of a case, when we say lots of matters pending, there is a difference between arrears and pendency. Right? A matter enters the mainstream, it becomes pending, but that is not an arrear. It has a life cycle. Every case has a life cycle. A writ petition has a particular life cycle. It's a civil writ, Article 2 to 6, 2 to 7. A civil suit has a different life cycle, and appellate jurisdiction has yet another. We have set patterns of setting the life cycles. It's only when it crosses that bar does it become an arrear in the real sense of the term. That's a matter of concern. And therefore we red flag it, right? We have green, yellow, red flags, which internally are circulated and told to us. Some people like me and many of our colleagues do that. When I enter a new jurisdiction, I ask for the data. What are the matters that are assigned to me? Which is the oldest matter on the board? How should I handle it? What should I do to expedite the hearing? So besides senior citizens and other categories that get priority, we on our own also tell the registry, okay, these matters of these years need to be brought up. Lesser dates, lesser adjournments. And that's where the legal profession must contribute to make sure that there are no adjournments being sought by lawyers, which is a big problem. If they seek adjournments constantly, how many times is one to accommodate them? It can't be. It's waste of judicial time at the end of the day. So there are several multifaceted issues involved in all of this. That's what I'd say. Yeah. Yes.
The latest survey saying that you mentioned public trust. And the fact that this thing was almost schools definitely creates public trust on the market. Thank you for that.
Thank you.
My question would be, ma'am, along the lines of what's your take on the concept of independence of judiciary, keeping in mind post-retirement jobs and political pressures, especially in light of the recent Justice Mukhopadhyay incident, where he resigned from judgeship and joined the political parties in 48 hours. And then the statement said that he was, prior to resigning, in touch with the political party.
So I think that was an aberration. And essays say that one swallow doesn't make a spring. It's never a case of everybody going that way. The very fact that there's one example over 70 years that you can give itself shows that it is not the rule, it is an exception. Not an happy exception, I would be the first one to admit it, but an exception. The public trust, you're right, does get dented with somebody like that who comes in this domain. But then the fact that the rest of the entire judiciary is not going that way itself strengthens the whole system. And when you talk of post-retirement assignments, well, firstly, the political pressure, it's many times more in the press. I, speaking for myself, have never had that occasion of anybody trying to reach out to influence the matter pending before you or influence the judgment in any which way. No, I can say with certainty. And also the fact that some people have this impression that one set of lawyers get more relief because they are seniors or they are seen more, or they are very influential, is something I would like to dispel. Is what you do, what your matter is, that is more important than who's appearing for you in a matter. Of course, if there are too many nuances legally, you would like to go for the best in a commercial dispute with high value commercial disputes. But that is not to say that in a simple family court matter or a simple partition suit, the judges would be biased because you are not a known name or a known face, right? That's not the case. And post-retirement appointments are mostly tribunals. There are also judicial tribunals, right? They are not, and those are also on recommendation of the Chief Justice of India, that the name is put before the, sent to the government as a recommendation. So one is not looking at that as a tenure, because luckily many of the retired judges are doing good arbitration work. Unlike other countries where ad hoc arbitration is not as much as it is in India, there are ample opportunities for a judge post-retirement to be able to find enough work to keep him or her engaged. Let's not forget, unlike this country, where a judge retires at 75 years, judges in the Supreme Court of India retire at 65 and in the High Court retire at 62, which is at that time a very active mind. In fact, many times you're at the peak of your mental frame to be able to contribute to the society. But then again, that's a call for the government to do. It has much to do with what the approach is. As it stands today, that being the age, you don't expect somebody to just sit at home and twiddle their thumbs. That would probably decline the health. The first thing, perhaps having led such an active life with mind buzzing 24/7. Yeah.
Well, we are running out of time.
Yeah.
Okay. I know you have got a lot of questions, but we have to. Zafar, I'll pass it on to Zafar.
Yeah, I'll just take a few minutes, of course, to echo the sentiments of everyone today, ma'am. And thank you so much for joining us and giving your valuable time to us. And thank you, Professor Bingham, for joining us. And of course, Ajit, for taking the lead on making this event happen. But last but certainly not least, thank all of you for joining us. Hopefully future members of the CCLS India alumni chapter, and some who already are members. And the best of luck to all of you in your careers after you leave Queen Mary. This is, as ma'am said, one of the best years of your life. So do enjoy it, take full advantage of it. And I think a big part of that today, thank you, ma'am, for the advice that you've offered and a lot of the perspectives that you've offered us today.
So much. I hope it makes a
join
difference
me, please, and thank you, ma'am, again. And CCLS for helping us host, ma'am, this afternoon, this evening. And thank you, everyone, for joining us.
Thank you so much. Thank you so much.
That was a patient audience. Thank you.
They're very good.
Of course.
Group photo.
Yeah. Sure. Just